Hello and welcome to Law and Life. I'm Shashank Mishra as a host with the eminent senior advocate of Supreme Court of India, Subodh Markandeji. Topic of today's discussion is judge's sentence to death, endless remedies. On November 2022, the bench presided over by the CGI dismissed a 20-year-old case by dismissing review petition number 286-287 of 2012. What in the nutshell is in the case, sir? Can you explain it, sir?
According to the prosecution case, Muhammad Arif, alias Ashfaq, was a resident of Abbottabad, Pakistan. He was an operative of the terrorist organization called Lashkar-e-Toiba. He appears to have sneaked into India and on 22nd December 2000, in the dead of the night, he along with six others intruded into the area where a unit of Rajasthan Rifles was stationed in the Red Fort in Delhi and opened fire. It resulted in the death of three Jawans. The accused scaled the wall on the rear side of the Red Fort and escaped. So this resulted in the FIR being lodged in the police station Kotwali, Chandni Chowk, Delhi. I think the FIR number was 688 of 2000. Uh, so the FIR was under sections 302, 307, 120B, 121 and other sections of the Indian Penal Code, read with the provisions of the Arms Act, which prohibited the possession of AK rifles, and Section 14 of the Foreigners Act and Explosives Act. So the accused were put on trial, and by a judgment dated 31st October 2005, the additional sessions judge, Delhi, uh, found them guilty of the charges against them, and at least this accused Ashfaq, that is Muhammad Arif, was sentenced to death. We are only concerned with him because it was not quite clear what happened to the other accused. Probably they were acquitted for want of evidence. So he was sentenced to death because he was a Pakistani national carrying AK rifle and other explosives, which were found later. And he was a foreigner, and Explosives Act was involved. So, uh, so he carried criminal appeals 891 of 2005 along with death reference number 2 of 2005. And after due consideration, the High Court dismissed the uh, criminal appeal, and on the death reference, the High Court affirmed the conviction and death sentence of Arif on 13th of September 2007. The Supreme Court also, by its judgment dated 10th of August 2011, affirmed the concurrent findings of the Sessions Court and the High Court. Then he filed review petitions numbers 286 and 287 of 2012, which were also dismissed. And, the last remedy of any litigant in the Supreme Court, that is called curative petition. So his curative petitions numbers 99 and 100 of 2013, as I said, the last outpost of any litigant in India, they were also dismissed on 23rd November 2014. So now Muhammad Arif filed a writ petition criminal number 77 of 2014. He contended that all review petitions in the death sentence cases must be heard in the open court, because the implication is that if he does not succeed, then he is put to death. So it's question of right to life under Article 21, which which uh, right is enjoyed not only by the citizens but by all persons within the territory of India. So some other people also who were sentenced to death like this and their review petitions were dismissed in the chambers by circulation. They also filed identical writ petitions. So they were all heard, and by a split verdict of 4 judges to 1, the plea was upheld. That is to say, the court came to the conclusion that yes, in death cases, the review petitions must be heard in the open court. And that is how the review petitions, which had been dismissed, were reheard by the Supreme Court at great length. And now, by the judgment dated 3rd November 2022, almost 20 years after the accused, committed the offense, the death sentence has been affirmed on rehearing of the review petitions.
Yes, sir.
So, this is how the facts of the case.
So when Arif's curative petition was also dismissed, which is the last judicial process of the Supreme Court after the
It's a very
disposal
good
of review,
question.
and how is this review petition could be still be heard, sir?
Yes, this is a very good question. Arif filed writ petition criminal number 77 of 2014, contending that dismissal of review petitions numbers 286 and 287 of 2012 in chambers by circulation was unconstitutional. And these review petitions in death cases must be heard in the open court because the consequence would be that life itself would be snuffed out. This plea was accepted by the majority, and Muhammad Arif was given a liberty to apply for making an application to hear his review petition in the open court.
So what exactly did the Supreme Court done?
So Supreme Court did what any criminal appellate court does. That is to say, it heard the appeals. So in appeals, the court has to appraise, analyze, and appreciate the entire evidence on record, and again apply law and decide the case. That's what the Supreme Court did.
So what were the contention of the accused in the second round of hearing of the review petition?
Yes, his contentions, as set out in para 12 of the judgment, are as follows. All the courts committed error in allowing call records to be admitted in evidence in spite of absence of certificates under Section 65B of the Evidence Act 1872. Second contention was that the disclosure statement which he made must be deemed to be inadmissible. Third contention was that recovery of ammunition or the encounter of petitioner's accomplice Abu Shamil at Batla House could not be associated with the accused. Then the fourth one was any possibility of retribution and rehabilitation of the accused, or that he would continue to be a threat to the society. This element was not considered. So these were the four contentions.
So what did the Supreme Court hold on reconsideration of the entire evidence?
On the first point, the court discussed this point in paras 16 to 23, and in para 24 accepted the contention of the review petitioner, that is Muhammad Arif, and excluded the electronic evidence for want of certificate under Section 65B, subsection 4 of the Evidence Act. But for the reasons given in paras 25 and 26, it held that even if the electronic evidence is excluded, as they did, there was ample evidence on record to clearly spell out and prove beyond any reasonable doubt the involvement of the accused, that is Muhammad Arif, in the crime in question. Therefore, he was liable to be given the death sentence. On the second point, the court held that the aggravating circumstances, namely the attack on the very sovereignty, unity, and integrity of India, far outweighed any mitigant or extenuating circumstances. In fact, the court held that there were no mitigating circumstances at all, and hence the death penalty was justified. In para 27 of the judgment, the the court held that points numbers 2 and 3 are purely factual in nature. The disclosure statement was held to be proved unanimously by the trial court, the High Court, and the Supreme Court of India. In the review petition, it's not possible to enter into questions of admissibility on issues of fact. The disclosure statement by the accused did lead the police to their hideout at G73 Batla House. And on arrival, the police team was fired upon, and Abu Shamal, the accomplice of the accused, died in the encounter. And a cache of arms and ammunition was recovered from Batla House. Therefore, uh, points number 2 and 3 were rejected. Now, now remained the last point. So the Supreme Court's discussion is contained in paras 28 to 30, occupying 5 pages. They have considered it in great detail. Uh, After considering the law laid down in the cases of Navjot Sandhu, that is that Parliament House attack case,
Yes, sir.
2005 5 SCC 600, Yaqub Abdul Razak Menon, 2013 Volume 13 SCC 1, Muhammad Amir Ajmal Kasab, that is 2012 9 SCC page 1, that is that Mumbai attack, and another case called V.S. Dupare. The court held that there was nothing on record to show that there was any mitigating circumstances at all, because the record did not show any mitigating circumstance. What the court has to do is to balance the uh, two kind of circumstances, that is to say the aggravating circumstance and the mitigating circumstance. So balancing them, they found that there was no mitigating circumstance at all on record. So far as the uh, uh, so far as the aggravating circumstances is concerned, the court said that material on record showed that accused was a Pakistani national, and he directly attacked on the unity, integrity, and sovereignty of India by acts of terrorism, which has been held in the cases which I cited to be the most aggravating circumstances, which completely outweigh the mitigating circumstances. In fact, there were no mitigating circumstances. So this ground does not merit any acceptance. In the result, the review petitions were, after hearing in the open court, dismissed by the bench of three honorable judges, that is Chief Justice of India, uh, Mr. Justice S. Ravindra Bhatt, and Mrs. Justice Bela Trivedi.
All this not contrary to the rules of governing review petition and the judgment in Rupa Sokharra and Asok Harra case, sir.
Yeah, I think this is worth consideration. See, Order 47, Rule 5 of the Supreme Court Rules 2013 bars the filing of any review petition after review petition is dismissed if it is disposed of by a judgment or order. There is no provision stating that after disposal of curative petition, no other remedy or any kind will be entertained. There is no such bar. But he had filed a writ petition, and I think there, you are right. Rupa Hurra versus Ashok Hurra, there is a long discussion in that case, which uh, which was the whole basis for providing the remedy of curative petition. Uh, that a writ petition, by a writ petition, you can't challenge a judicial order or judgment. And that's why the provision was made by way of curative petition. So, in that sense, the maintainability of writ petition number 77 of 2014 was questionable, but that's a decided case. So, there is nothing we can do now. But at that stage, I think someone should have raised the point that writ petition against a reasoned order or judgment does not lie. And that's why the curative remedy was evolved by the Supreme Court itself.
Of course, sir.
So
And that's,
curtain ran down on this case after 22 years.
yes, sir. Yes, finally it has been done. Thank you, sir. That's all out for the day, sir.